Can you be held responsible for debt that your spouse took out in their name only during your marriage? It's a terrific question. My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues right here in the state of Michigan. And today, we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. This is a terrific question because it deals with the issue of debt in one person's name. You know, debt is contractual, meaning that if you have a credit card in your name with, Michigan National Bank or whatever bank it is that gave you the credit card, or Visa or Discover, you have a relationship with them. You have an obligation to pay. Nobody else has that obligation. Your spouse is not obligated to pay your Discover bill. But you have to understand, your spouse is not a party to the contract, but there is a marital contract between the two of you. And the marital contract basically says that any debt that either one of you incurs during the marriage, with a limited exception, is going to be regarded as marital, which means even if it's in her own name, half that $5,000 bill belongs to you. You're obligated to contribute to it, not necessarily to Visa or Discover. You don't have an obligation to them, but in the marriage, there's an obligation, so that if there is a divorce, half that debt becomes dad's, half that debt becomes mom's. That's the way it goes. Now, if it was a debt that he had before the marriage, it was only in his name, that's a different story. The court, in a lot of these cases, will simply say, you know what? You keep whatever you had before the marriage in your name, and you keep the debts before, you pay those and you pay those. That's fine. But once it's incurred during the marriage, it really doesn't make a difference whose name it's in. The question of who splits that marital debt is not a question of in whose name is it in, it's a question of when. When was that debt incurred? And if it's incurred during the marriage, guess what? It belongs to both of them, even if it's only in one name. Now, creditors might be able to pursue, let's look at it the other way. Let's say we do have a credit card and it's in both names. So you have a Discover card. It's in mom's name and dad's name, joint account, and only one of them works. The credit card company can go after you for 100% of the debt that's in both names if you're the only one working. So notice how this works. If it's in one name but it's marital, both of you have the responsibility. If it's in both names, one of you can be stuck with the full responsibility. Now, having said that, it only relates to the relationship between the creditor and the people who signed on. But even if they come after one person because it's a joint credit card, in a divorce, both parties are still obligated. So even if they'll come after one, let's say they're only coming after the husband because the wife doesn't work, husband can negotiate the half of that debt on his side in the divorce proceeding. And maybe he can get more of the house, or he can get more of the 401k, or he can get a bigger share of the money to cover her half of the debt that he's now being garnished on. If you have any questions about that, reach out. We'll be glad to help you out.
248-588